part. Your attorney, Mila Schwarzreich, suggests that you comply with, please thank Mrs. Comply with Florida Statute 193.011. Please thank Ms. Schwarzreich for clarifying this. However, the issue had to do with 31 USC 3124. I believe that the United States Code supersedes state statutory code, though I may be incorrect. This specific question with regard to 31 USC 3124 was not specifically answered. Since Ms. Schwarzreich chose to reference Florida Statute 193.011, can you please provide your definition of the word cash or immediate equivalent? It is my belief that the words referred to in Florida 193.001 parentheses 1 cash or its immediate equivalent would include Federal Reserve notes or debt obligations of the United States. If your definition, the word cash or its equivalent thereof, excludes Federal Reserve notes or debt obligations of the United States, can you please provide your definition? Yes, I fully understand and agree that under Florida Statute 193.011, there are other factors you are required to adhere to in deriving just valuation. It is not necessary to discuss these other factors. The only concern in your definition of cash or its immediate equivalent, the only concern is your definition of cash or its immediate equivalent. I'm not interested in anything to do with the millage rate, as I'm not sure why Ms. Schwarzreich brought that up in the first place. The question specifically has to do with the debt obligations of the United States or Federal Reserve notes in assessing property value within the County of Broward, and then applying that property valuation based upon debt obligations of the United States in the computation of the tax by a state or political subdivision of the state. I'm not sure if Ms. Schwarzreich did not understand the question. I'm not sure why Ms. Schwarzreich chose to accept and then convert a dollar to certify a copy and return a valueless thing where there was a requirement, a wet ink signature for your true and accurate property tax assessment for parcel number, blah, 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 based upon the market value in Federal Reserve notes. As previously suggested to you with September 1st demand, it is required by the state for the citizens, persons, or residents who request benefits subject to liabilities to provide a wet ink signature on state forms. Therefore, it would not seem unreasonable to require the same requirement upon a public official declaring the property tax assessment complies with all laws of the land. Since this service was paid for with a Federal Reserve note, I'm not quite sure how Ms. Schwarzreich can convert a contractual intent into something clearly not intended. I can forgive Ms. Schwarzreich conditioned upon she can forgive me if I have made an error in my understanding or any other matter from these two correspondences. Anyway, to make it very easy so there is no misunderstanding, I will ask the question again and know that there will be an answer. It will be answered directly, completely and honestly by you or your authorized agent. Oh, watch. As property appraiser, some of it got cut off. As, can you process, some of it got cut off. Within Broward County, United States, for the purpose, do you use in any form, manner, or specific whatsoever, in whole or part, a debt obligation of the United States or Federal Reserve notes to determine any part of assessed value? It's a yes or no question. If you use debt obligations of the United States or Federal Reserve notes in the assessed property valuation, and then that valuation amount is used to compute a tax, does that violate 31 USC 3124? Yes or no? Whether you send the actual property tax bill in November or another Broward County agency, such as Broward County Tax Collector, this question should be interpreted with your knowledge of a fact to answer the question directly. Number 3, if you do not define at any time the present cash value of property or the immediate cash equivalent thereof to include debt obligations of the United States or Federal Reserve notes, please define your exact meaning of cash or immediate equivalent thereof. Number 4, if you use something other than debt obligations of the United States, 18 USC 12 USC 411, or Federal Reserve notes, are you as property appraiser able to tell me if this current specie or other debt obligations of the United States can be used to discharge the debt obligation for parcel number, whatever it is, at the time of the presentment of the property tax bill, which arrives on November 2015? Yes or no? In the previous correspondence dated September 1st, I required that you as property assessor, property tax assessor or appraiser to provide your wedding signature and return the actual notice of proposed property taxes and proposed or adopted ad valorem assessments thereto attached. This property tax assessment was to be signed by you as a Laurie Parish as a duly authorized constitutional officer as attesting to the accuracy and the truthfulness of the actual individual 2015 notice of proposed property taxes and proposed or adopted ad valorem assessments for Rubio Anthony with the following statements. I declare or certify, verify, or state under penalties of perjury that the foregoing is true and correct property tax assessment based upon market value in Federal Reserve notes on January 1st, 2015 for parcel number blah blah and closed on date and with your signature. This verbiage is here to attach to your 2015 notice for your convenience. When signed with wedding signature, please return original to Anthony Rubio. Number 6, if you will not sign the statement as outlined in question 5 above, please state the reason. Then I go on, your failure now, willful and intentional, to respond directly, honestly, and completely this time within 5 business days after receipt is your tacit agreement that you use debt obligations in the United States in your assessed valuation, and then from the property valuation, a tax is computed from the assessed property evaluation in violation of 31 USC 3124. Therefore, your property tax assessment for 2015 for parcel number is non-compliant with the United States statutory requirements. Please note, to respond that your office does not give out legal advice or that I should seek legal counsel is a non-responsive response and deemed dishonorable. I'm not looking for an opinion or legal advice, just the facts. If I had made an error, it is my understanding in whole and part, I first ask that you forgive me, and then secondly, to help me by correcting my mistake and misunderstanding, as we are all fallible. Laurie, I'm not trying to back you or your office into a corner or get away with anything. My good faith intent is to support and aid the United States during its declared national state of emergency, which dates back to the 1930s, and that goes under 12 USC 95A. I hope you can agree with my support of the United States, and let's work together to help reduce the national debt for future generations. This is why I go through this exercise, and maybe if you understood the why behind this, you may even appreciate, though not necessarily like, what I'm trying to accomplish for future generations. If you would like to discuss the matter in private, I am open to this. Please let me know in writing, otherwise I will require a direct and complete and honest response within 5 business days. Thank you, may God bless you, and I do mean this, so as I trust that Almighty God will guide you as you go. And again, so anyway, I should give you the certified letter numbers. Let me do that for a second. Hold on. On that letter, it was certified mail 7014-3490-009676-9609. On the previous letter, the one pager, that was certified mail, that was dated September 1st, 7014-3490-00009676-9685. What I'm trying to do is create a record. So I got to tell you, this is so cute what Mila wrote. So Mila responded to this. I don't think Mila's too bright. She's an attorney, but you know, see, that's Mila's letter. So your letter dated September 17th Dear Mr. Rubio, while you did not find my previous letter a satisfactory response to your inquiry, it was indeed a response and was the only response to your inquiry you will receive. Thank you for your kind words. Sincerely, Myla K. Schwarzreich, General Counsel. So, you know, I guess it's like Hillary. If you ignore it, maybe it goes away. So I got the tax bill and I took care of it, which I shouldn't have because, you know, I didn't want to get too angry with it. But what happened, I decided to send Lori an email. Now I got to tell you something. Lori is so cute. I love Lori. So let's see if I can get this out. Anyway, it was dated, I think, the beginning of October. Lori agreed to admitting using U.S. currency and U.S. dollars, but she did not admit to Federal Reserve notes. So anyway, I'm going to read the next two responses to you, or not two responses, two more exhibits I sent over to the Value Adjustment Board. Again, forgive me that I'm lengthy with this, but I want you to understand what I did. Like I said, I took care of the taxes last year, but I decided, well, this is the year that we're going to get this directly answered, or they're going to pay it, and I'm going to do something with it. I don't want to harm anybody. It has to be responded to. So if they choose not to, you know, you can't force anybody. I don't think anybody wants to do that, but the thing is then it has to be let out publicly that if a property tax assessor can't sign what their claim is for property taxes, that it likely violates U.S. code, then what we have is a fraud upon the public, and then it needs to be told publicly, and then if enough people stand up and start demanding that their quote, it's not really their property tax assessment. If people start requiring that the actual documents be signed and it violates the law, then it looks like they're going to have to think of a different way to get, I guess they call it money or whatever it is, debt obligations of the United States. Anyway, I hope you're all learning from this. And that's it. I'll get back to you in a little bit.